10, since Mr. Baker held his for a long time. Mr. Crittenden, would you do the invocation, please?
Yes, ma'am. Let's stand, please. Heavenly Father, again, we want to thank you for this day of life, this opportunity to come together, to catch up on things that's been going on and do the work of our people. Pray, Father, for those that are unfortunate this morning and that might be sick or lost loved ones. Pray for our soldiers. Father, go with us now and help us do good work for our people. Continue to bless our country and help us to do what's right. In Jesus' name I pray. Amen.
Roll call.
Meredith Braley.
Here.
Bill Angler.
Here.
Bill John Baker.
Here.
Jack Baker.
Here.
Harley Baker. Julia Coates.
Here.
Brad Cobb. Joe Crittenden.
Here.
Jody Fishinghawk. Here. Janelle Fulbright. Here. Don Garvin. Chuck Hoskin Jr.
Here.
Conora Jordan. Present. Curtis Snell.
Here.
Chris Soap.
Here.
David Thornton.
Present.
Carol Town White.
Bonnie. We do have a quorum. The purpose of this meeting, the election law was tabled, I believe, in tribal council back to committee to consider recommendations for, or suggestions for change under certain sections of the election law. And is Melanie here? Melanie, I think the majority of these are to be considered after a contract lawyer, I understand, looked at them or something.
Yes, and you'll notice as you go through the changes, a lot of just the corrections to references, referring to the right constitution. A lot of them are typographical or connecting the references, changing member to citizen. There was one or two of those. So by and large, a lot of them are not substantive changes. The one substantive change that you should consider, I think it was also discussed in full rules committee, was separating out the districting section of this law because of the litigation that's ongoing, and reserving that portion and passing the remainder so that the election commission can go forward with the updated law. So I'd be happy to answer any questions about any of that.
Mr. Hopkins?
What is and I know we had a discussion about this, but what purpose does it serve to strike the district limit, which in fact is the law of the land right now? Isn't this just Section 5 just restating what the law is now? And if that's correct, what's the point in striking it?
The chief would not want to agree to legislation at this point because of the legislation that is opposite to his position in the litigation, and so he would find himself in a contradictory position, I believe, if he signs off on a law that's passed with it in.
The chief really thinks that if he signs this legislation that the court will consider that some kind of an admission that this is constitutional?
Well, there's at least one other instance I can think of where he signed a resolution of the council's appointment of a commissioner to the election commission, and the court determined that he was approving that particular appointment to the election commission. So I don't think it's out of the question.
I'm not familiar.
That's his concern.
I understand that. I'm not familiar with that case, but I can't really figure out under what scenario the court, having to decide whether redistricting is constitutional, they would consider that. But I understand the chief might not want to take that risk. I frankly don't think it's a risk. But that aside, I really don't see a reason why this body would not just simply restate what is already the law of the land. I mean, couldn't the chief just issue some sort of a signing statement along with approving it, saying, I approve of this, but I certainly don't admit that it's constitutional, because the constitutionality of redistricting is not even in this statute. It can't be. It's not. We're not the arbiters of it. I just wonder if he would back off that. It seems much ado about nothing to me.
I understand the counselor's position. I don't think that that the chief believes there's any harm in reserving that section, because the law is what it is today and it's being considered as to constitutionality. I think he does not want to make any kind of admission that might be construed as something else in the court, and if he signs it, I don't know that a qualifier would suffice, and so I think that is his position, is that why go there? That if we can simply reserve that issue, the courts will decide, and whatever the courts decide will be the law.
Thank you, Madam Speaker.
Any other questions? Mr. Hembry? Oh, excuse me, Mr. Garvin, I'm sorry, I didn't see your
I have
hand.
one question on number 16, page 4. It says Cherokee Nation will have an election every 4 years. Shouldn't that be every 2 years?
Section 16.
No, number 16 on page 4.
Okay. What, in Madam Chairman, what I was going to do at your behest is I have a series of notes that we would go in sequential in order, and that is one of the items that I would ask to address.
I'll withdraw the question to the
Thank you.
So if that is the will of the committee, I think we could go through several of them very quick. Page 1, there's no changes I would recommend. Page 2, section 3, under authority, the new language is this title is enacted pursuant to Article 9, Section 1 of the Constitution of the Cherokee Nation, ruled, effected, and ordered implemented by the Cherokee Nation Supreme Court on June 7, 2006. That's not entirely accurate. It was ordered on June 7, 2006, but the court ruled that the 1999 Constitution became in effect and was the law of the land on July 26, 2003, when it was approved by the voters. So I would suggest just an additional language saying that taking it right from the Supreme Court case, saying which became the law of the land on June 26, 2003.
Move to change that wording.
Second?
Moved in second, any discussion? Any
Can we have him read it as it's changed to us one more time?
I would suggest this change. This title is enacted pursuant to Article 9, Section 1 of the Constitution of the Cherokee Nation, ruled or ordered implemented by the Cherokee Nation on June 7, 2006, which became the organic law of the land on July 26, 2003. And organic law of the land is the exact language from the court case.
Any further discussion? Is that clear? I'm sorry, Ms. Callen-Watts?
Thank you, Madam Chair. I can't support this at this time because the time we took, although I think it's been very intentional and very well spent, we are so near the election at this point that I think we need to pass something that doesn't risk the potential of stopping the Election Commission from further implementing the changes and getting the word out and the policy changes that we need. And I think this puts us at risk for that. Thank you, Madam Chair.
Mr. Hoskin?
And I appreciate her comments, but I wonder if Councilwoman Canwatts could clarify, you're not in favor of passing any of the changes that have been presented, or was it a specific one?
No,
if I could direct the
just the
question?
deal with the redistricting stuff and anything to do with the litigation. Thank you for allowing
Okay,
me
and
to
so,
clarify.
okay, so I understand the Councilwoman is not in favor of striking the districts as recommended by the administration.
Oh,
Okay.
I thought we were on
Yep.
Section 3, authority.
Section 3 is the first time.
And we had a motion and a second, and we're in discussion on correcting the date to July 26, 2003, correct?
Yes, and my recommendation is that as written, it doesn't accurately reflect what the court decision held. Yes, the order came down June 7, 2006, but it implemented the Constitution on July 26, 2003.
Right. Ms. Fishingham, did you have?
That was just my question. What we're doing is changing this to what the court has already said.
Yeah.
Okay.
Any further discussion? Further discussion? All in favor, signify by saying aye. Aye. All opposed, same sign. Motion carries. Okay, Mr.
The next one is Section 3A definitions. On the third line, under 1, It says jurisdictional boundaries of Cherokee Nation have not previously registered. I believe that should be changed to who has not previously. This might be the one grammatical error I ever catch, and I hope that I'm right.
Means a person, yes. Okay.
Does that make sense? Okay, that I would, as a Scrivener's replacement, I would recommend
Ms.
that.
Thornton?
Under this same definition, does this coincide with the Constitution?
Yes.
Okay. The way maybe I didn't misunderstood it, but if after the first election under this Constitution, if you wasn't already registered, if you sign up like this time to run, that you will have to be, and you're at large, then you will have to vote at large. Is that the way I get this?
If you are age 25 or older, and believe you me, this will be open to much interpretation, but if you're 25 years and older, you have a one-time chance at your first registration to pick a district, okay? And that's ongoing, and we've talked about that, and we've made changes or made clarifications in the law previously. But this language is language of the Constitution, and I would just...
Are you talking about this last election or this coming election?
Well, the last election, and if you're 20, and as you register, you still get that ongoing shot.
If you're under 25 and have never registered, then you still get that ongoing shot?
My understanding.
Correct.
Okay, is that the way the Constitution?
Yes.
They figure out what they were trying to do. Most of these people that are under 25 are third generation Californians. I mean, they're not even connected.
That was a day and a half, I believe, of the Constitution itself and Constitutional Convention itself. It was a vigorous discussion. But that is what the Constitution says.
Okay. Then, after the last election, if you were over 25, you had one shot.
Yes.
But from now on, if you're under 25 and you register to vote, then you can choose either in the district or out of the district.
That's my understanding.
That's what it said.
Yeah.
I didn't understand that. I never got to read it. Thank you.
Any other questions on,
And then, that being, would you want to take a vote on that Scrivener's? I would just go ahead and just acknowledge that
it's just Scrivener's to change from have to has? That's the only change, right?
that is correct. Number 6 on that same page, constitutional amendment. Says constitutional amendments means constitutional amendments proposed by the Cherokee Nation Council that are submitted to registered voters of the Cherokee Nation for the purposes of voting on said amendments at a special or general election pursuant to Article 25, Section 2 of the Cherokee Constitution. Also, I believe that this definition needs to be amended to include also Section 3 of Article 25, which allows the right of the people to provide a constitutional amendment. There's two ways to do a constitutional amendment. It's the council's majority vote, and then there's a petition, I believe, by 15%, if I remember correctly. But it just needs to be consistent with the Constitution that there's two ways to have a constitutional amendment, council and amendment.
Second.
Moved in second, any discussion? Todd, that you want to insert that, where you suggest inserting that?
Yeah, inserting section, Article 25, Section 3 also.
Further discussion? Baker?
So it should actually say proposed by the Cherokee Nation Council or by
Initiative petition.
initiative petition.
Yes.
So that should,
Yeah,
so we should add the initiative petition also and then add the other section.
that is correct.
Everyone clear? All in favor, signify by saying aye. Aye. All opposed, same sign. Motion carries.
I see no necessary changes on page 4.
Sir,
Yes, okay.
number 16.
Oh, number 16, well, there you go. I just jumped again. Oh, page 3, I skipped page 3. Yes, I would recommend on the third line, saying general election means a regular election for offices of the principal chief, deputy chief, and for seats on the Cherokee Nation Council. I would delete the words starting in the year 1975 and occurring every 4 years thereafter, and simply adding as provided by law.
Make a motion to approve.
I'll second.
Moved and seconded. Todd, exact, so that we're all clear,
Strike
repeat that exactly.
on definition 16, line 3, strike the words starting in the year 1979 and occurring every 4 years thereafter, and adding the language as provided by law. Yeah.
Everyone clear? I have a motion.
Okay.
Mr. Garvin,
I made the motion.
second.
No second.
Mr. Baker. All in favor, signify by saying aye. Aye. All opposed, same sign. Motion carries. Dr. Cobb?
Page 4, number 18, Melanie, you may want to jump in on this too. Do either of you see anything by the line that says described by the patents of 1838 and 1846, diminished only by the Treaty of July 19, 1866, that opens the door for anything regarding our Delaware memorandum or any jurisdictional issues in the current vicinity of Washington County?
I don't see any problem with this language. It comes directly from the Constitution, and is something we've used in legislative acts since that time, so I think I have no problem with it.
I have no problem.
Foresee any issues.
I have no problem with it.
Thank you.
Madam Chairman, also on definition 16, we would, I would suggest that on the last line, you would add, where it says Article 25, Section 2, you would also add and Section 3 of the Cherokee Nation Constitution. We've just previously said that dealt with constitutional amendments. And then on definition 17, second line, where it says the Cherokee Nation for purposes of proposing any legislative matter and constitutional amendment pursuant to Article 25, Sections 1, 3, and 5, and 6. Because the constitutional amendment can be done by initiative petition.
Isn't that 15 instead of 25? Does X mean 10 or?
Oh, no, it's 15. It's 15. You're right. Sorry. It's been a long time since I did my Mormon. But I would just add, and again, that's just making it clear that a constitutional amendment can be done by initiative petition. Going to page 4, I see no recommended changes on page 4. I'm going from my book.
Top right or bottom left?
Top or
Or
bottom?
bottom?
Top, I'm going by the top. Oh, I'm sorry.
Mr. Baker?
I move we approve the changes in item 17. It's recommended by Mr. Healy.
Second.
Moved and second that item, 17, did you say?
Yes.
Okay, be approved. Any further discussion? All in favor, signify by saying aye. All opposed, same sign. Hello.
On page 4, top of the page,
Top of the page.
I see no recommended changes on page 4. Page 5, we come to the reserve, section 5, whether you want to remain the section 5 in here or put reserve. I would add the words pending court determination in Smith versus Election Commission et al. CV 0965 to make it perfectly clear that we were referring it to a particular court case. But to me, and I spoke with many of you, it's 6 or 1, half dozen of the other. It's just whatever the council wants to do.
Mr. Anglin and then Mr. Baker.
Well, I was just going to move that we insert the language that Todd just did.
Second.
Moved and seconded. No discussion, Mr. Baker?
Yeah, how's the election commission going to proceed if we just leave a hole in this document?
Well, you still have an outstanding act out there called Legislative Act 1408, I believe is it, and that created the 15 districts. That was vetoed, and the veto was overridden. That's still the law of the land, okay? That's still an independent act out there. From what I've talked to Secretary Knight state today, the chief doesn't want to be caught in a catch-22 or a gotcha position, that he doesn't want to defend having to sign an act that he has previously, or language that he has previously vetoed.
But in lieu of, by having this hall, the law of the land is what's been struck.
Section 5 just reincorporates Legislative Act 1408 in the, that is the act. And this is all pending. And one thing that I was going to announce today is that on February 5th of this year, or next month, we're going to have an evidentiary hearing on the districts. And therefore, so we can expect we've been promised a quick decision from Judge Fite on the constitutionality of that section. So it is ripe. It is before the court. We do have a court date. Again, it's just whatever the will of the council is.
We passed this.
Mm-hmm.
Election Commission is going to read it just as if these red lines weren't there, because that's already the law of the land.
Correct.
The only thing that will change it will be if the court says to do something different, or we come back and change it.
That is yes, that is correct.
Okay, thank you.
Mr. Hoskin?
If the court finds redistricting, as we did it in the earlier law, constitutional, 15 districts were constitutional, and in the meantime we pass this with the redistricting language struck, okay, would we then have occasion to go back to this act and say, now that it's been upheld as constitutional, let's memorialize this by amending this act? Would we need to do that?
My answer would be no, and this is why. Again, we have the Act 1408, and I hope that's the number, but I believe it is 1408. That has gone through all the legislative process and the veto process and the override. That is the law of the land. This simply is basically part of the codification process, where you incorporate that act into this act. We're not repassing the act, and that's the way I see it. And if the court were to held that our 15 districts are constitutional, nothing else needs to be done. But during the codification process, you would incorporate that act into your general election statute.
Because my concern would be if we did have the need to revisit Section 5 and insert what hopefully would then be constitutional language concerning districts, that we'd be back in a situation where we're sending something to the chief's desk and he vetoes it because rather than constitutional reasons on which he lost, policy reasons on which you can always use. So I just don't want to get into this. I guess I'm as risk averse as the chief is when it comes to this law, and I think I can't support striking it, but I do acknowledge that the risks are not as severe as I thought they were when I first read this, but I still won't support it. Thank you, Mr. Speaker.
Sure. Mr. Corey Jordan?
Who made the motion to pass this?
Buell.
I would suggest a friendly amendment then as a compromise that we just entirely take out Section 5, not reserve it. You said it wasn't needed. The law is already there. What's pending before the court will change the law, not change this. So as a compromise to everyone, just remove Section 5 so that we send a clean set of rules to the Election Commission to go by. And there's not a hole in them. We'll take Section 5 and everything's going to be numbering wise would be changed as we go on. We'll just simply remove Section 5, and that would be my offer of a friendly amendment to Buell.
Could we leave just the 5 in there just for, and not reason?
From what I'm hearing from Todd, we don't need it, because we've got a law that, the law of the land now, that there is a pending lawsuit on, so if the lawsuit changes it, it's gonna change the law. If we just take this out, we're done with this election law, and we can send it on to the election commission, we don't have to revisit it again. That's my understanding of what you just said.
I see no problem with that logic.
This is a restatement of something that we already have in another law.
Yes.
So it basically doesn't have to be in here at all, now or in the future.
You could do this, you could put section 5 reserved, or you could put section 5 representation by districts, reserved, asterisk, see Legislative Act 1408.
Or we could just take out representation by district and just, if you want to leave a section 5,
Okay.
just say reserved for
Okay,
future
that
use
even
and
makes
not
more
put
sense.
anything.
There you go.
That was.
There you go.
Thereby, there's no reference, we won't ever go back and revisit this.
Then if the courts rule in favor of the
It
redistricting.
has to do with the law, it doesn't have to do with our election
I'll-
laws. We won't ever have to come back and see this again. We can send it to them. They've got their marching orders.
I would agree if we leave the 5 in and then leave the reserves in.
Yeah.
However, the Commonwealth is-
That'll work, that'll work. Yeah.
Second.
I have a question on 1408. These districts are, that is, I mean, these are the districts
Yep.
of 1408,
Yes.
correct?
Yes.
Okay, I accept.
Steve. Cambry,
I see absolutely zero problem with that.
Mr. Garvin,
Tell us a little bit more about February the 5th. Is that the final or just a warm-up or?
It's a warm-up. It's the final on the district court level, and then I'm pretty sure
What
that
happens next?
appeal to the Supreme Court.
Thank you, ma'am.
any other?
But I was going to send a memo out to everybody.
Any other questions, comments? All in favor of removing leaving the numerical number 5, correct? But removing all the wording. Is that the way you understand you, Dr. Cobb? All in favor, signify by saying aye. Aye. All opposed, same sign.
Aye.
Aye.
And it'll just say Section 5 reserved. Okay, page 6. This is a question I had, and maybe this is probably for the Election Commission on term. So the Election Commission shall be appointed as soon as practical, preferably within 6 months following the expiration of the term of the Election Commission which served prior to general election. And then it says each commission member shall serve a term commencing with the day of appointment and ending October 1 of the general election year for which he or she served as an election commissioner. Is that still your all's terms?
We're not on the same page as you are.
Page-
Got you today, and we are, would you like to see what we have? It's nothing like what you're talking about,
Well, this is what we were told we would be
that
going
you'd be
by.
going over today. And I did remember reading that a few minutes ago, but I can't find it that quickly.
Okay.
We're not numbered the same way.
So we would look at page 4 of 30, section A. Section 11A. It's the same thing, it's just email.
Okay, Mr. Embry?
Yes. So my question is that your terms right now? Or do you know? Because I don't.
Our terms finish at the end of the election,
Okay.
and we are reappointed or not reappointed when the new term starts. And a lot of times I was appointed months into the next term, so I can't answer all that.
Well, the reason I ask is that I want section A to, as we'd say in South Adair County, to G and Ha, with section A1, which Chief. Which, that, yeah, you do start in October, but then, are you guys on your staggered terms? Have you guys? Okay, well, if we pass this law, you will have to, get on staggered terms, so.
It was our understanding, the final on this would read something to the effect that we would remain in office until we were replaced.
Okay. All right, and it does say that. There is a holdover clause on here. So I guess we're okay, but that was just a question I had.
Ms. Corey Jordan and then Mr. Baker.
Well, I guess I need to direct this question to the Election Commission. Have they not been provided with these changes so that they could review them too?
Yes, they have. They have.
Well, but that's not what they've got back there, Todd.
It's just not numbered the same, I think, is what we're saying.
We called and asked, what document that we would be following today, and this is a document that we were told that we would follow. And obviously, it isn't. Or someone's following two documents, I'm not sure.
Oh, it's numbered different.
Yeah, and I'm by the pages of the book that was sent to all the council.
Pages in the book are in the right-hand corner at the top.
Right.
Top and bottom up?
Top and bottom. Well, that's the bottom.
Well,
The
but-
one we're going by, the one we're going by is at the top, right?
Yeah. And at this point, I would ask the committee to turn to the next page, which would be page, yes.
There's no change.
Number 7.
8?
8.
7.
7. Mr. Baker.
7, 8, 7.
On page 6,
Okay.
above A term, where it says by the executive office of the Cherokee Nation Council, it should be by the executive office or the Cherokee Nation Council as it originally read,
You're right.
because it's two different.
Yeah.
Which one is that, Mr. Baker? I'm sorry.
On page 6, just above A term, under Election Commission Establishment and Appointment, the last line.
I would recommend the original language and no motion would be necessary.
Madam Speaker, it would have been a great assistance that whoever rewrote these, if they would be present, so that we could find out why they rewrote them. What
You mean
they're,
the staff or the...
well, I understood there was a contract lawyer that did this. Can that person be made available?
That
I don't know, did we hire a contract lawyer, the council, or who hired somebody to look at these?
It's my understanding that there was an attorney hired by the principal chief to go through the document. From those recommendations, a meeting was held, and what we call the cleaned up version from those initial recommendations were put forward by Secretary Knight. That's in the packet that you have here.
Was this somebody in law and justice, or, where's this person at?
It is my understanding that the attorney was an attorney by the name of Karen Graham. She's in California. She does do special projects for the chief.
Is she like a specialist, I guess, in election law?
I do not know her qualifications.
Well, I'd like for that person to come before us so that we can dwell into what her idea was on that we need to make these changes.
Yeah, these are the I think what's important
That
is.
would be my request to the chairperson.
Okay. Melanie, you have an
I would
explanation?
submit that, Ms. Graham, assists the chief, represents the chief on those matters that the AG cannot represent him on, including the litigation that's going on right now. And that these are the chief's proposals, and if I need to call upon him to come over and explain rationale for any of them, he's willing to come over and answer questions. But I'm here in his stead also to do that. So
Is she his personal attorney or something? I'm at a loss here. I don't understand.
some time back, and it was around the time that the AG Act was passed, it was determined, in fact it's part of the AG Act, that in those matters where there is a conflict between the branches of government, that the AG's office cannot represent the chief in those matters. And so he was budgeted for and has hired outside counsel to do that. Much like you hire outside counsel to represent you in those matters sometimes.
Except we don't have that budget anymore.
There is a budget, yes, for
For us?
outside counsel, yes.
For us?
It's been reduced, but yes, it still exists.
Do we still have such a budget?
Been reduced.
You got any money in it?
100,000, I believe. I believe it's 100,000.
Does that answer your question,
Well-
Member Jordan?
Well, I'd still like for this individual to come and talk to us. I'm intrigued by some of the changes that were made, and I would like to hear her analogy of why we need to do this. And I would like to find out more about, are we being guided by someone that is an expert in election law? I don't know, Miss Graham, did you say?
Yeah.
I don't know her. I'm not familiar with her work. I would just like to know who's giving us guidance. And when did we come to have a conflict? He's not vetoed this. And that is his right to veto something that is submitted to him. So when does the conflict start?
I don't see any of these changes as being necessarily controversial. If there's any questions, as I said, the chief's available. These are his proposals, not Ms. Graham's proposals. So he's available to answer questions about them.
Okay, Ms. Count-Watts and then Mr. Hoskins.
Thank you, Madam Speaker. Because I understood that what is actually the document in front of us has been worked through by Secretary Knight and is being presented by her on behalf of the chief, and the work that I think that Ms. Graham had done prior to. And just to clarify, I understood we had spent $80,000 on an outside lawyer already this year. So maybe I'm wrong, but I think we have spent considerable money, and I haven't seen that person in front of us. So if we're going to make that a standard, we should probably do that across the board for both
Is that your
branches.
request?
I'm just telling you, I didn't do any of that.
Yeah.
I'd like to
I didn't
see
hire
this.
this person, so.
I'd like to see these
Uh,
folks.
Madam Chairman, what I'd recommend at this is that we go through the changes. If the council wants to request that Ms. Graham come before the council, that is obviously up to the council itself, but it's not germane really to the act itself. And on this note, if the attorney that Ms. Calvin Watts has referred to, his name is Michael McBride. Yes, he is an outside attorney that I have used in defense of the Smith versus the Election Commission and council lawsuit. He's an attorney that we've used on and off throughout the last 10 years, and I'm sure he would be happy to come to the council and report on every issue that he's worked on.
Mr. Hoskins?
I don't want to belabor it, but does Ms. Graham represent the chief personally, and she represents the chief in a separate capacity, which is the drafting of this legislation? Personally, in that he has sued in connection with the redistricting, and then separately that she's in the review process for this legislation. Is there a distinction there drawn, or is it all one?
I think there is some distinction because in the review of this, it was more around the policy matters concerning this, which the AG's office has been clear to me that they won't advise us necessarily on whether it's a good policy or not, just whether it stands legal muster. And so on policy issues, it pretty much left us to, making those policy determinations on our own. And so, in this capacity, my belief is that she's advising from a policy standpoint.
Thank you, Madam.
Ms. Fishinghop?
I'm curious, how much has been spent on this Graham version?
That is a GRA that you've made to me. I think I just received it today, and so we'll submit it to you. I can't tell you off the top of my head. I can tell you that she has worked on a couple of probates that are outside the nation.
Excuse me, just for a second. Doug, can you go look that up real quick?
Yeah, he can run a report.
Yeah. Okay, go on. I'm sorry, I just wanted him to do that
He
real
can
quick.
run a report.
Okay.
Oh, sorry, Ms. Gloria Jordan?
What kind of probates? I thought that was done by Linda Donaldson's office. Or is there
What I
a
was getting
conflict
to-
on some of those?
What I was getting to and what you'll see in the report of payments,
Point of
that is
order.
not under this contract. If we want to get into, the GRA requests all this information, so I'd be happy to provide it under that, and it would be correct and in on all the detail that she's requested it.
Okay, Mr. Henry, get on with
I
the
had
election law,
one
please.
other part, if I could.
Okay, one more, and then he needs to continue on. We have about 10 minutes.
I am making the request of the chairperson that we ask Ms. Graham to be in attendance, and Mr. McBride if we think we need that person, but I certainly would like to hear from Karen Graham on some of these changes, and I am making that request to the chair.
Okay. Thank you. Mr. Henry.
Yes, if we could direct the committee's attention to page 7, top right-hand corner. I would recommend no changes on page 7. Page 8, I would recommend on definition 12 that it remain the same language. The reason being is that that language was in the original law, and that was as a result of a court case in which a judicial office was being filled by the council, and it was done so by secret ballot. That was then appealed to the Judicial Appeals Tribunal, which said that that vote was improper because all votes of the tribal council had to be in public. So therefore, I would recommend that definition 12 remain the same as written.
So leave, the one that's struck out, leave that in there.
That would be my recommendation.
Mr. Baker?
Yes.
Do I have a motion? Are you going to make that motion?
No.
Oh.
Or is
Do I
it
have a
under the-
motion?
Under the current
Just a
constitution.
moment. I need a motion and a
Second.
second. Who made the motion? Mr. Hoskins. All right, now discussion.
Okay, under the current constitution, the council does not fill,
It's grand, I've never seen it.
We would feel
they fill if there's less than half.
less than half, they feel it.
Okay.
Or
More than that.
more than half
Is
is
a
special,
general-
is a
is
special election.
Okay.
Less than half the council fills it if the person that came in second is not eligible to be there.
Okay. Thank you.
Okay. All right, Mr. Henry, carry on.
Page 9. Oh, I'm sorry, there was a motion, I'm sorry.
Sorry, too.
I would recommend a vote be taken to,
All right, now we've got a motion, second discussion. All in favor of leaving number 12 as originally written, signify by saying aye. Aye. All opposed, same sign. Okay.
page 9, upper right-hand corner, I would recommend no changes. Page 10, upper right-hand corner, I would recommend no changes.
Mr. Baker?
Yeah, you say no changes, but I'm sitting here reading it, and there's a stricken insure and attempting, and there's things being changed, so we're not.
Well, thank you for pointing that out. I would not recommend any changes from the draft that you have in front of you. All the changes on pages 9, for instance, are numerical, and there's clarifying some sections on page 9. Section 10 is grammatical. I don't see, there's no substantive red line version.
Well, I mean, on page, and I'm not being argumentative, if we need to take a vote, we need to take a vote, but like on number 2, it says voter registration, precinct, and then you've added the words where each person is attempting to vote. And, I mean, either we're going to do it or we're not.
What page are you on?
10, second paragraph, the second line.
Yeah, it's, to me, it's grammatical. I mean, if you want to, you can pass it all at the end. What my position is that I would want to go through each red line and point to you out where there are substantive problems.
Okay.
Now, you could, at the end of the day, say we're not going to do any of it, but I'm just pointing out the substantive ones.
Gotcha. All right.
Page 11, on section 14C, midway through the paragraph, it's starting with the line, the administrator shall be under the direct supervision of the election commission, and at all times the administrator shall maintain independence. That line is stricken. then it says, and report to the council and principal chief through the rules committee, and having the historical knowledge on that. I believe the language, the administrator shall maintain independence, was originally language of Councilperson Callan Watts, and wanted to make sure that you were copacetic with deleting that language in there.
Yes.
Okay, all right. Other than that, I
have my head down. Mr. Baker and then Ms. Gloria
Just-
Gordon.
Item C, Administrator, that first line, the end of that line says shall A be, we should strike A. Shall be, or actually, it should be switched, shall be a Cherokee tribal
Right.
citizen.
My mind's clear on that one.
Thank you.
Okay, Ms. Gloria Jordan.
Now, where you're talking about taking out the administrator shall maintain independence, what was your reasoning behind us doing that?
well, the original language, the administrator shall maintain independence and report to the council and principal chief through the rules committee, that was specifically part of an amendment of the council, and I remember that specific language being used. Now, although it may not be grammatically flow well, that was specific language that the chief is recommending that we change. That's why I'm, anytime there was, specific language added to this election law, and now it's stricken out, I felt duty bound to, to bring that to your attention. And like I said, only the subject ones.
Mr. Hoskin?
So, why does the administration want us to strike this? I may not have a problem with it, I just don't understand.
Well,
the section on independence. Is it just
section 14C.
And also to that, why the administrator's not reporting through the rules committee? I guess two questions on why.
The chief is here and Secretary Knight's here. So.
Are you going to respond?
Sure, okay.
Mr. Hoskin?
Okay, so what's the question?
The question is, why is the administration recommending that the phrase, I take it that the phrase, the administrator shall maintain independence is being struck. Is that the recommendation?
Basically, it was just syntax. It's not that they should not be independent. Because what you had in here is several offices that were not defined. And so when you have different offices that were not defined, the roles become unclear. And so in this instance, I tried to create some consistency as to who the administrator was of the commission, and that the language right here through the rules committee is in a statute. You try to leave it as broad as possible, and the council can designate the internal process who the committee or whatever organization the election commission should report to. So it's not necessarily council. It doesn't say the council as a body, it just says the council. And the council has the authority to designate whatever committees or committee the council would so choose. And as you're quite aware, when you have a constitution, it's the broadest terms. And your statute is a bit more specific, and then the finite detail that may change from time to time can be done by rule or regulation.
Thank you, Chief. Thank you, Manager.
Yes. Any other questions while it's present? Okay, Mr. Hoskin. Mr. Hembry. Oh, I'm sorry, Ina.
Yes, Madam Chair, since the time is 3 o'clock now and we have another meeting right after this, I move to table this item until maybe in one more month we can have it in an order where it can be sent to the Election Commission.
Table section 14C
table, well, we need
The
to
whole
send it,
thing.
yeah, we're gonna have to get through the whole thing, so let's table it all until next month and then finish it up.
Have a motion to table, do I have a second?
Second.
All in favor, signify by saying aye.
Aye.
All opposed, same sign. Aye. Okay, yes is to table.
Brad Cobb,
No.
Julia Coates.
No.
Harley Buzzard,
No.
Jack Baker,
No.
Bill John Baker,
Yes.
Bill England,
No.
Claire Callan Watts, David Thornton,
Yes.
Curtis Snell,
Yes.
Chris Soap,
No.
Tyler Jordan,
Yes.
Chuck Hoskin Jr.,
Yes.
Don Garvin,
No.
Janelle Fulbright, Meredith Brady,
No?
Jody Fishing Hawk,
Yes.
Joe Crittenden.
Yes.
Madam Chair.
9 nay.
7
Yay and 9 nay.
7 yes, 9 no. Motion fails.
Madam
Yes,
Chair.
Mr. Baker.
I move we recess until 2 o'clock tomorrow, where we can have plenty of time to go through this and finish it up.
Have a motion to recess, do I have a second?
Second.
All in favor, signify by saying aye. Aye. All opposed, same sign. Motion carried. Now, then, Mr. Hembry, can we finish this up tomorrow at 2 o'clock?
It will, I will do my utmost to assist the committee in.
All right, thank you. Entertain a motion to adjourn.
So moved.
Thank you.
All in favor, signify by
Recess.
Recess.
Recess, yes.
Okay, we'll recess. Get out of here.
There's no way. There's no way.
No, you couldn't keep up with who was on what page.